But a community of thieves produces thieving politicians and thieving judges. It doesn't produce saintly judges. So, if a person has been on remand for more than the constitutionally provided period, there is not much you can say to justify why he is not released.
As a judicial officer?
Yes, on bail, because the constitution says you should. And it does so in an unequivocal way. It does not say he should be released if he meets these conditions. No! It says so many days, release. It doesn't even have to have sureties. They don't have to be substantial. He doesn't have to be a good man. No! So, even as a judicial officer, how do you explain overlooking such a straightforward and unequivocal and services to a client? Of course, the other thing is that after an election, both parties are exhausted financially. An election petition is very exhausting, and yet you'll be working for a person who doesn't have money because he had
and you know it.
Yeah, he has spent the last coin in the election. Sometimes you say, but is this worth dying for? From an earning perspective. And some of us are not in these things as crusaders. You are not in it. That before these books came up, a judge in Arua sitting in an election petition,
a high court judge,
yes, would make a decision without knowing what a judge in Kabale has decided on similar facts, or the one in Masaka. And sometimes they would reach different decisions on the same facts. Now they have the latest position from the last court. You know, in parliamentary election petitions, when you lose in the High Court, you appeal only once to the Court of Appeal. Its decision is final. So when the Court of...
You would advise the executive not to bother appealing?
No.
And you think he shouldn't?
Yes, because the Computer Misuse Act in its original form was good enough for purposes of preventing certain abuses of computer technology. But to now keep inventing new areas of gagging, of
restrictions.
Yes, it's not desirable. It's not desirable. That's why you only see it in certain types of countries and not in others. It's not that they don't feel offended by certain attacks, but they know that the greater good is served if you let these ideas flourish.
Do such things impact you on foreign investors?
Oh yes, you wanted to know whether the image is affected. I can see you are cleverly bringing back that. Yes, of course, our image, and indeed our image has been greatly battered over the several years, because you see, this is one of many other actions which point at a more intolerant regime, and people notice. You remember, as we speak, World Bank and other Bretton Woods institutions cut back on aid. First because of the Anti-Homosexuality Act, but also because of suppression of political dissent. And as we go on, more and more are doing that. The Nordic countries, West generally, they are doing that. So, these measures that government is doing are not helping anybody.
Investors would prefer environments
of course, a modern
restricted.
Yes, a modern investor. There are some investors who don't care. For example, investors from the Chinese background.
Yes.
They can afford to operate.
They don't like a dissent.
Yes, they are used to so-called orderly society where the Mukuru is not attacked. But
there is a strong state.
Yes, but for example, the Western-leaning investors, one, they want to see a free society because they know what it means. They want to see an independent judiciary. They want to see a progressive parliament, and they want to see a public that expresses itself
freely.
Yes, because that creates certainty
and innovation.
Yes. Because you see, people fear that although people may keep quiet, they could explode any time if they are suppressed. And no one wants to risk huge sums of money in such an uncertain society whose stability cannot be predicted because it's stability founded on fear rather than on vibrance and hope, you know,
And freedom.
and freedom. Yes.
Okay. Now, it was invalidated by court because it breached many of the rights created under Chapter 4.
Yes.
Can we briefly talk about this Chapter 4? What was the basis for its enactment?
Yes.
And what makes it so important in our constitution?
Yes. There was a time when this country did not have the equivalent of Chapter 4, a Bill of Rights. But from independence onwards, the constitutions had a Bill of Rights, which is what Chapter 4 now is. Now, the 1967 Constitution had a Bill of Rights, but the restrictions against the enjoyment of the rights were so many and so far-reaching that the rights had been abridged until they were almost meaningless. The 1995 Constitution was supposed to have started a new regime where the rights take precedence over the limitations. Yeah. Now, what happens with the laws like the one which has been struck down, the Computer Misuse Amendment, is that you are going back to a regime where there are so many clawbacks on the enjoyment of rights that the rights are rendered meaningless. It's not desirable. Indeed, what could be happening is only slightly better than completely removing Chapter 4, the Bill of Rights. Of course, everybody knows that in the modern times, perhaps the international community would not accept to have a country among its membership which does not have a Bill of Rights at all, though they can accept one which has rights which are circumscribed by limitations. So the more limitations, the worse. Because, and the Supreme Court and the Constitutional Court have been emphatic about it, what is fundamental are the rights, not the limitations. So the limitations should be as minimal as possible, only in deserving cases where they are necessary for the enjoyment of the rights of others and in the public interest. And the public interest itself should be interpreted narrowly, not to include suppression of legitimate enjoyment of rights. Yes.
Now, the government of Uganda, from what we've seen over the years, they are very uncomfortable with the rights which are created under that chapter. What do you think would happen? Why? Because they have amended this constitution many times.
Yes.
Each time they have found an obstacle, they have resolved it through amendment.
Yes.
Why do you think they are cautious and have not proceeded to delete this chapter?
Yes, because of the backlash that they know would come, not only internally but internationally. As I said earlier, it is no longer possible to completely do away with the Bill of Rights. You would be rendered a pariah in the community of nations. So possibly they cannot go that far. So what they have then been doing, you realize the amendments to the Constitution have largely not touched the Bill of Rights.
Correct.
So what they have been doing is to limit the scope of these rights through other legislation, not a constitutional amendment. Because I think even they, although they are impatient with these rights, they realize that in a modern society, it is no longer possible to do away with some of these rights.
Get isolated.
Yes, you would attract so much backlash that it's not worth it. So they just try to minimize them through what we call amendment by infection. You know, you amend them indirectly through enacting laws supposedly for implementation, which laws then limit the scope of these rights.
Which make them unconstitutional.
Yes, and that's why then the activists try to ask court to declare such laws unconstitutional.
And each time they have gone to court, they have succeeded.
Yeah, and once in a while they succeed. Of course, there have been also cases where they have not succeeded. You know, courts have to be careful to avoid the impression that they are fighting the executive. There is a way, as a court, you also don't want that fight. So then Once in a while, when the executive goes too far, they will strike down the law. But until then they will, they will live with a bad law in the greater interest of not rocking the boat. I'm not saying I support that, but I understand the considerations that considering the relationship between the executive and the judiciary, the background against which the members of the judiciary are appointed, the way they are funded. It is not possibly practical to expect that you have a judiciary that will go all out to defend the rights of the individual, irrespective of the sentiments of the executive. So they do it in a piecemeal way. They do it in one statute, then not in another, so that every 10 years maybe you get one bold decision and many weak ones, and you move on.
You balance.
Yes. So whenever you get a bold decision, then you take advantage of it. Then next time you are not so lucky, and you move on. That is how development through activism works. Because you see, this is development by reform, not by revolution. You are not going to overthrow the order and replace it with another one. You are hoping to keep improving
like
the
they
order.
do in Pakistan.
Yes, we don't seem to have the critical mass that would be able to do that. So you can understand where the courts are coming from.
Sir. So sometime back, something called the administration of the judiciary law was enacted.
Yes.
And
2019.
among other things, it enhanced the welfare of judicial officers.
Yes.
People earn much better. They even retire with their salaries and for life. But this has not resulted into a better judiciary. What do you think about that?
Yes, it has not, because it was not intended to. You see, that act has certain positive provisions, but the spirit under which it was made it potentially a dangerous law. There is a school of thought which feels that it was a negotiated law. We give you tax, we give you a bigger budget, in return you overlook certain failings. You cannot find that in the law itself, of course.
But the practice.
But everybody knows the atmosphere under which the law was enacted. So it created the danger with such a law. It created, of course, it made the working conditions of service of judicial officers much better, which we all wanted. But there is a possible danger that then it created too close a relationship between the executive and the judiciary, that we have done what you wanted, we expect you to also be reasonable with us. Be reasonable. Reasonable, of course, can mean you look the other side when certain unhappy things happen. Secondly, when you look at that act, I have studied that act very carefully. It creates something called the Judiciary Council. Now, when you look at the constitution of the Judiciary Council, there are so many stakeholders who are represented on the council. And many of those are stakeholders who have no interest in an independent judiciary, quite the reverse. And yet now they make decisions supposedly for the well-being of the judiciary. So the danger with the administration of the Judiciary Act is that it concentrated on
welfare.
Very good, welfare. Visible things, buildings, bigger budgets, retirement benefits. Such a law was not meant to address the non-physical thing of the relationship between the three arms of government. You also see it in Parliament. The welfare of Parliament improves, but in return, the executive gets blurred in the camaraderie that comes with discussing the improvement of welfare. So such a law can actually be counterproductive in the long run, even if to the individual judicial officer his working conditions are improved. Yes.
But still, even on non-political decisions, I don't think they have become less corrupt. For instance, even in decisions which have nothing to do with the political sensitivity,
You see,
they are still not efficient.
yes, some of the dangers we make is think that corruption exists because people are poor or are in need. That is driven by want. My own experience is that corruption is a mindset. It is not forced by hardship and the scarcities and so on. I learned that right from the days of the founding of the Uganda Revenue Authority in 1991. When it was created, it was given, the workers in the URA were given terms of service that were way better than their counterparts had been getting under when revenue collection was a Department of Finance. And the thinking was that now that we'll be paying them enough, they will have no excuse to be corrupt. But of course, they were not any less corrupt than the traditional members of the public service. Perhaps they were even more corrupt in some instances. Now we go to the judiciary. I do not think a judicial officer takes bribes because he's earning little. No. Because he could then have decided not to be in the judiciary and he goes into private practice and makes tons of money. Why did they choose to go into the judiciary? Sometimes it is because they think there are opportunities for corruption there. So corruption is fueled by mindset, not by scarcity and want and need. So no amount of salary is ever enough. That's why some of us decided to be in private practice, in addition, of course, teaching at the university. Because salary is never enough. Even if you pay a judge 100 million shillings, that is no guarantee that you will not be corrupt. We know that money breeds more wants. If you are earning 2 million and suddenly you start earning 10, you dream of 20. If you get 20, you dream of 50. That is only human nature. So people will not be corrupt simply because a new mindset has been created, not because they are paid better.
So what do you think the people of Uganda who have had to pay this price to say let's have our judges paid better, they have paid a big price because other projects of government have had to wait. What should the people of Uganda do in order to get a better judiciary?
Promote judicial accountability. You see, when you are in the judiciary, you tend to emphasize judicial independence because you want to be left alone to do your thing until you are out. Then you realize that in addition to judicial independence, you need the counterbalancing force, which is judicial accountability. Judicial accountability is a wide concept. It includes writing a judgment that is of good quality, but it also includes combating and ensuring that the judiciary is not corrupt. It includes efficiency, that you efficiently dispose of cases. It includes fighting case backlog, and really ensuring that people get good value for their money. It also means that we now have to rethink the way we appoint judicial officers. In some neighboring countries like Kenya, an applicant for a position of a judge is subjected to public scrutiny. I don't understand why in Uganda we first had a progressive constitution before Kenya did in 2010. Why should we still be treating recruitment of judges and other judicial officers as state secrets? It should be open. People should be able to come up and expose those who are not fit to be judicial officers. Some of us in private practice know. Sometimes people are appointed and say, oh, even that one? Well, technically he qualifies, but is that the best you could choose from the mass of lawyers in this country? But they pass. So, until you open up,
in Kenya, they have a platform to give such feedback.
Yes, members of the public comment, and we don't have it here. And there is no good reason why we don't have it. Maybe some of the very worst cases, in the judiciary would have been avoided. Maybe those who now feel they don't want to be part of a judiciary that has so many questions around it, and so they don't offer themselves, would offer themselves if they felt that the system would recognize cleanliness, and integrity. But as it is now, I know many people who cannot think of being part of the judiciary because they feel they don't want to belong together with some people who are not questioning. I'm not saying the whole judiciary is rotten, but I'm saying once you allow in one or two, they stand out. A bad apple stands out in the midst of 100 good ones. That is only human nature.
And they become now the standard bearers.
They become the litmus test. And the good ones, they are the exception rather than the rule. There is even a feeling that some of the very good ones are never promoted. They are treated badly.
They are punished for being
Yes,
good.
they are punished for being good because the standard practice is to move on, is to overlook many things. Yes, it is. This country doesn't seem to reward integrity sometimes.
Now, as a lawyer and a scholar, when you look back at 20 years ago, 10 years ago, 30 years ago, the judiciary we had fewer judges, they had limited resources, the facilitation was less, the resourcing was less, the cars, the logistics you need to do the job, the infrastructure, the offices. Today we are much better off than it was 30 years ago.
Yes.
Do you think when you look at people like Sekoko, people like Katusi, Mulenga and the others, do you think the judiciary has gotten better or worse?
You see, sometimes even those things we think are now better now are because the country itself is much better, better off than it was then. I think the country now affords better pay and better terms of service and facilitation for judicial officers than before. That alone means inevitably a judge today will be facilitated better because the economy can facilitate better. It also means you can have more judges because the economy is bigger, the population is bigger, and so the judiciary will be bigger. So quantitatively, that is to be expected. Now, I don't seem to see that the better facilitation has resulted in a better judiciary. With fewer resources, it seems to me that the judges of yesteryear did a better job of looking out for the rule of law, protecting the rights of members of the public, protecting the image of the judiciary and the independence of the judiciary, and even delivering justice.
The quality of judgment.
Yes, they seem to have done better quality work with less resources. And that is something that should concern us, that with all the resources that are now available, a huge budget for the judiciary, we still complain of basic things like backlog, which then leads you to believe that when you emphasize material improvements, better courts, better housing for judges, computerization and so on, without a corresponding improvement in the quality of the judicial officer, you may miss the picture. And by quality, I don't simply mean training, because there are trainings all the time. I mean moral quality, because that really is the problem. The judges today maybe are better trained. Almost every judge now has a master's and beyond. They have certificates and diplomas galore. But that
they have research assistants.
Yes, they have research assistants. They have the computer. They have
internet.
chemists. They have Yuli, where all the laws are at your fingertips. But why then don't we seem to have better quality outputs? The gap could be a moral gap, not a gap in resources. So yes, resources are good. Resources are important. But if you emphasize them at the expense of moral growth, you lose the picture. Yes.
Could it be a problem of leadership as well, maybe?
Well,
Aspects of the institution?
we can use a cliche that people get the leaders they deserve. You will not get judges from heaven. You'll still get them from your own community. A community, I said that at Makerere one time and it looked controversial, but a community of thieves produces thieving politicians and thieving judges. It doesn't produce saintly judges. So we all really must work to have better standards as a people. Because assuming the judiciary was rotten and everybody else was okay, they would not survive.
It will not be sustained.
No, they sustain it because they are a reflection
That's
of
the
what we are.
environment where they
Yes,
operate
that's the
in.
environment. So it becomes permissible and indeed becomes morally upright. Looks like you are awkward, you are odd. Yes.
Now, Doctor, I know you are familiar with the Besigye case,
Yes.
this active case which is ongoing.
Yes.
In which ways would you say it has exposed the Ugandan judiciary?
Well, I've seen the battles.
People think it has brought out the worst. It has.
As a practicing
You
lawyer,
think they have managed it well?
as a practicing lawyer, I am hesitant, of course, to to address a live case, an ongoing court case, in terms of the merits of interlocutory processes when the case is not completed. But I could also tell you that I'm personally known to some of the protagonists on all sides in that case. So I may not be at liberty to speak my mind the way an academician should. But a judicial officer, of course, should always be concerned about not just whether justice is done, but whether it is seen done, because this is an ongoing case. But it is possible that a big section of the public feels justice is not being done.
The perception.
The perception. Now, a judicial officer should always have his finger on the pulse of the perception. Perception is very important because you could do good work, but you are not seen to have done good work. And so that would dilute the work you are doing. Of course, you also must not play to the gallery because your first point of call is not to perform for the public to like you. Your first point of call is justice. But justice is as important in what is done as in what is perceived to have been done. And so as a judge, you must be conscious of that. Especially when it is felt over and over that maybe on these matters, maybe the accused is not given full protection of the law. You cannot avoid that feeling sometimes. I can point at one point especially. If a person has been on remand for more than the constitutionally provided period, there is not much you can say to justify why he is not released.
As a judicial officer?
Yes, on bail, because the constitution says you should. And it does so in an unequivocal way. It does not say he should be released if he meets these conditions. No! Says so many days, release. Doesn't even have to have sureties. They don't have to be substantial. He doesn't have to be a good man. No! So, even as a judicial officer, how do you explain overlooking such a straightforward and unequivocal and clear constitutional provision? I think that one cannot be explained. Yes.
Thank you very much. There is something called mediation. I'm sure you.
Yes.
Recently, it was announced by the judiciary that it's going to be mandatory for all election petitions to be subjected to mediation before they go for full trial. What's your view about that?
Well, I have been a supporter of mediation generally, especially commercial mediation, I was part of those who started it in the commercial court from the point of view of the practitioner and who supported it. But I have some reservations on how far you can mediate a political contest, because our politics is the politics of winner takes it all. So you mediate and then do what? And we share the seat in parliament. We mediate and you pay me and you pay me and I back off. Because
wouldn't that be against even public morality?
Of course it would be. It wouldn't be acceptable. But there could be room for mediation in terms of narrowing down the issues so that only limited issues can go for trial. Sometimes you throw in 100 grounds of petition when only one makes sense. If mediation can whittle away the 99 which are useless, and then the trial judge crystallizes on one and makes a decision, it could save time. But I am not certain that you can settle an election petition entirely through the process of mediation. Except maybe if the mediator will show one side that you don't stand a chance. And maybe if it is the petitioner, then he withdraws. If it is the respondent, he concedes. Short of that, mediation of an election petition may not be as impactful as mediation in commercial matters and other civil litigation matters. Yes.
What do you think generally has been the impact of mediation from commercial, where you
in the commercial and civil sphere, it helped to resolve many long-standing cases sometimes. I have been associated with cases which were in court for close to 20 years, and in 1 week you mediate it and resolve it. So it had great impact. Even when we introduced it in the Court of Appeal, you know, mediating an appeal was an unusual thing when it began. Someone has already lost and another one has won, and they are on appeal. But strangely, we got very many positive settlements outcomes, or partial settlements. And so my view of mediation in those spheres has been very positive. But as I said, I wonder how far you can stretch it. Yes.
Have you been involved in some election petitions?
Yes,
for this season?
No.
Some instructions already?
No. My experience in the past with election petitions was so unpleasant that I made a decision not to be involved in them again. In an election petition, you are dealing with people who are out to finish each other. And when you take one side, you are part of the enemy who should be crushed.
You can be misunderstood.
Yes. I can tell you when I was still a young lawyer in 2001, there were petitions we handled where we were basically, diving, from bullets when we were trying to gather evidence, when our lives were in danger. So I got a bad experience and I didn't see why I should expose myself to danger in the name of giving services to a client. Of course, the other thing is that after an election, both parties are exhausted financially. An election petition is very exhausting, and yet you'll be working for a person who doesn't have money because he had
and you know it.
Yeah, he has spent the last coin in the election. Sometimes you say, but is this worth dying for? From an earning perspective. And some of us are not in these things as crusaders. You are not in it because you believe this candidate against the other.
Business.
You are not in it as business professionally. So then you find that it does not make business sense to be in the midst of this campaign of hate without any serious pay. So what I've been doing, I have been handling election matters from an academic point of view by analyzing judgments of the courts and by writing
Tell us about that.
Writing books which digest the decisions of court in election petitions. And so for me, that's the role I have chosen to play.
It's a contribution.
A contribution in which I don't make money, but in which I make the law available and usable for those who want to.
You
use
empowering and facilitating those
Yes.
who are pursuing
Yes.
those court
Yes.
cases.
Yes.
Okay, finally, sir, you earlier today you at Law Society you talked about recount. What exactly were you talking about today?
Oh yes.
What was the message?
Last year, we wrote 2 books. The first one was titled Enhancing Electoral Justice in Uganda, and it was a review of the Court of Appeal decisions arising from the parliamentary elections of 2021. The lead author was Justice Professor Tibatemwa Chirikubinza, and I was a co-author together with Dr. Daniel Ruweza of the School of Law, in which we digested all the decisions of the Court of Appeal out of the 2021 election petitions. And in doing so, we were able to trace what law those decisions have developed in terms of election petitions. So afterwards, we made another one, myself and Justice Tibatem again with the Justice as the lead author, and it's called Principles and Practices of Vote Recount in Uganda, Jurisprudence from the Courts. We found that under the, we knew that under the 1995 Constitution, there are provisions which allow recount instead of a full-blown election petition. Someone who loses an election can demand a recount in certain circumstances. And so over the last many years, especially since 2001, courts have made decisions on principles governing recounts. But those principles were scattered in about 50 cases. So we put together those cases and filtered out what principles the courts have developed, which should guide a court now if it is faced with a recount. We found that there are 4 situations in which you can have a recount in an election, in a parliamentary election especially, but also presidential. 1, under Section 54 of the Parliamentary Elections Act, if the 2 candidates tie, 2 leading candidates tie, they have the same result. Or if the winner and the runner-up are separated by a vote margin of less than 50 votes, that section says the returning officer must conduct a recount. So it's a mandatory.
He doesn't even have to go to court.
No, all you do is write to him and say, we now want this recount.
You the aggrieved.
Yes, he does it himself. It doesn't go to court.
Okay.
Yes, because the mathematics is so close that they want to have a second view of it. And so it is, he recounts the votes under the eye, the watchful eye of the stakeholders, the candidates or their agents.
That's within 1 day, 2 days?
Yes, immediately. Immediately after announcing, you say we want a recount, he recounts and declares by the next day.
That was a decision of High Court?
No, that is a provision of the Parliamentary Elections Act, Section 54. Then, Section 55 provides for another kind of recount. This time, the returning officer has declared a successful candidate, and of course the votes of all the others. Any unsuccessful candidate can demand a recount.
Even if he was not number 2, number 3,
Any
candidate
can demand a recount. And if he gives good reasons, a recount will be conducted. An application for a recount has to be made within 7 days of the returning officer declaring the success.
That's now to court.
Yes, the application is made to the Chief Magistrate's Court. When the Chief Magistrate accepts that you have made out good grounds, he orders a recount. The polling materials, which are normally kept under proper custody, securely, are then brought, and the Chief Magistrate himself, or herself, conducts the recount. Becomes the successful candidate. If the other party is not satisfied, there seems to be no provision for appeal, but you can have a review by the High Court.
That would happen regardless of the margin, or
Yes.
that second scenario?
That second one, the margin is immaterial. We are saying the mathematics is not satisfactory. I think they have not counted well. So they count valid votes, invalid votes, totals, and so on, and state whether what the outcome is. It may disagree with the returning officer, it may not. The third recount is when that has not happened. Then when the results are gazetted, the unsuccessful candidate, any of the unsuccessful candidates, or a voter in the constituency supported by signatures of 500 voters can petition the High Court. Okay?
This is after the gazetting?
Yes, it happens after the gazette, within 30 days after the gazette. Yes, you file an election petition.
That's now a petition.
It's a petition. You can petition. Now, in a petition of that nature, one of the things you can ask for, you can ask the court to recount. You can say, in fact, you don't even have to call for a fresh election, just count them well.
Yes, there is a remedy.
Yes. One of the remedies you can have is a recount, this time now by the High Court, within a petition. Then,
and that's really taken advantage of.
Yeah.
It really happens.
Then under Section 59 of the Presidential Elections Act, you know, when a president is declared after an election, you can petition the Supreme Court challenging the declaration.
You have been a candidate to do that.
Yes. Now, when a candidate challenges a presidential election, again, the Supreme Court, under Section 59, I think G, 59, subsection 8. One of the things the Supreme Court can do, it can also order a recount, either in the whole country or on some stations. Yes. But that has never been done in practice. Now, the problem we found with these recounts is that they never happen. Why? Because when a chief magistrate orders a recount upon an application, the chief magistrate, he can only conduct the actual recount if he finds that the integrity of the electoral materials has been preserved. If he finds that the ballot boxes in which the papers are kept have been tampered with, the seals are broken, or they are opened, or maybe they are contaminated. If you find that the integrity has been not been preserved, has been compromised, then the recount cannot continue. It must be stopped. Now, what has happened in practice is that in almost all cases where recount has been ordered, they find that the materials have been tampered with. It's as if it's deliberately made to frustrate recounts. So, on many occasions, courts have ordered recounts, but they have not happened because they find the materials have been tampered with and the integrity of the materials cannot be assured. So what we ask actually in this book that I showed you is, could it be that there are people who are interested in preventing recounts?
It seems obvious.
Yes, and why do they?
Yes.
Could it be that somebody is aware that the results that are normally declared leave a lot to be desired, and the recount would expose that? Your guess is as good as mine.
And the law does not provide any sanction for whoever could want.
No, unfortunately, it does not. It does not. Yes, and it does not even give another remedy to the person who had sought a recount other than filing a full-blown petition, which is extremely expensive and which has its own legal challenges. Yes. Yeah.
That's what the book is all about.
Yes.
So you had gone to the Law Society to publicize that?
Yes, the book on recounts was brought out and launched informally shortly before the elections were held. The parliamentary elections were held, so that those who wanted to have a recount would take advantage of it. Unfortunately, many people did not know of its publication, and they continued gambling with the authorities, which are scattered all over. Yet it would have saved them a lot of work. A few of them got to have it, and the report we got was that was useful. So we now wanted people to know that it's there. Of course, you are not going to have another recount until the next
Another 5
round of
years.
elections. Because you must apply for a recount within a week of the elections, and the week has already passed. Then the other one on election petitions. This one is still continuing to be
People are
useful
fighting.
because they are fighting right now. And this, together with another book produced by Justice Tewate Mwechili and Dr. Businje Kabumba, which analyzed the 2016 elections. Together, those two books basically have put in just 2 small volumes all the law, the current law on election petitions, the principles that the courts have enunciated in the course of making these decisions. So again, once you have these 2 books, your homework is done for you. You can tell quickly off the page what the law is, what the standard of proof is, who can petition, how you prove, what kind of evidence is allowed, how you appeal, when do you appeal, what grounds can be brought out, what do courts consider in nullifying an election, and so on and so forth. It is all now set down. You no longer have to look at 200 something decisions scattered from courts all over the country.
Even you might misunderstand some of
Yes,
the,
I was explaining
decisions.
in that interaction at the Royal Society that before these books came up, a judge in Arua sitting in an election petition,
a high court judge.
yes, would make a decision without knowing what a judge in Kabale has decided on similar facts, or the one in Masaka. And sometimes they would reach different decisions on the same facts. Now they have the latest position from the last court. You know, in parliamentary election petitions, when you lose in the high court, you appeal only once to the court of appeal. Its decision is final. So when the court of appeal pronounces itself on an election petition, that's the final position. So now we know what the final court on election matters, parliamentary election matters, has stated to be the principle. And so you are well guided. So we thought that these books are very important to give us a good, consistent picture of what the state of the law on election petitions now is.
It's helpful to petitioners, to lawyers, and the judicial officers.
Even, yes, if the politicians who are going into politics, members of the public who want to know whether their candidate has a chance, whether their candidate was treated fairly. So it's a book that anybody interested in the growth of the law should be interested in.
Where can or should people find copies?
Yes.
And at what cost?
Copies are now being sold at the Supreme Court. I think the Assistant of Justice Chirikubinza has copies which are on sale. We have just availed copies at the Uganda Law Society offices. We are going to put copies at the School of Law at Makerere. And very soon we shall announce any other places where copies can be bought. Of course, by the end of this month, we could put copies in the major libraries, bookstores in town.
The Aristoc
and so on, Uganda Bookshop, for those interested.
Why do you need a whole month, sir? Is it because you don't have enough copies?
No, we actually have enough copies. And our worry is that they are not being consumed yet. We produce them at great expense. I may inform you that the one on election petitions was funded fully by the judiciary. Yes, the production of this book was fully funded by the judiciary, and the judiciary supplied copies of these books to all the judges. So they have them. But then there are copies for those members of the public and the legal fraternity and others and academics who may want to buy their own copies. That's why I told you where you can buy them.
What's the cost for each?
55,000 shillings each.
Each?
Yes, each.
Okay.
Yes, so for the judiciary, they have it because they produced, they paid for its production. Yes.
Have you considered an online version?
Yes, we did. Since it was produced on judicial funding, we have to get permission to put it online. But we have already agreed with the URI, the Uganda, the the institute which puts together decisions of courts of record and so on. And they are going not only to put it online, but they are also going to feed it into their systems so that when you research on a legal point which this book deals with, the ULI web page refers you to relevant pages of this book and takes you there. Exactly as they do with statutes and decided cases.
Okay.
Yes, so it is going to be free and available.
Thank you very much, sir.